Today I'm talking about the 10 days that you have to give a municipality notice that you're bringing a lawsuit. This is a really short timeline. Today I'm talking about the 2 ways that you can argue around it if you did miss the 10 days. I'm Natalie Gerry, the principal lawyer and founder at Gerry Law. I help injured people get the compensation that they deserve for their injuries. Section 44 sub 10 of the Municipal Act 2001 mandates that for incidents that occur on municipal sidewalks or municipal roadways, you must provide notice of the incident and your intention to sue within 10 days. This is a really short time frame. The section in question states failure to give notice or insufficiency of the notice is not a bar to the action if a judge finds that there is a reasonable excuse for the want or insufficiency of the notice and that the municipality is not prejudiced in its defense. What do these things mean? These are the 2 different ways that you can get around this notice period that would normally mean that you cannot bring an action at all. If you are injured and you haven't given that 10-day notice, you need to look at what has to be accomplished so that you can still bring your lawsuit. That first thing is a reasonable excuse for the delay in providing the notice within 10 days. And the second is that the municipality is not prejudiced in its defense as a result of the delay in giving the notice. In terms of what constitutes a reasonable excuse, that was fairly recently clarified by the court in a City of Toronto case, Graham and the City of Toronto. In that case, the court decided that the notice letter was served in time to give them notice, even though it was nearly 3 months after the incident happened. In that case, though, the court decided that the notice was not late enough to make it so the plaintiff couldn't sue. We need to look at this case for what we can learn about if this happens to you. If you're more than 10 days, what are the factors the court will look at? In this Graham case, the plaintiff had tripped and fallen on a large pothole on a pedestrian crosswalk. She sustained a tear to her right rotator cuff, a strained neck, injured her right elbow, right arm, and right hand. She needed surgery, and 15 months after the incident, her right arm was completely immobilized for 6 weeks. And at the time of the incident, it is notable that she had a very busy career. She had a job that was taking a lot of her attention. She worked as a director at a capital management company. She returned to work immediately after the incident, but resigned from this role approximately 18 months later because of the surgery, the treatment, and the recovery time, and this was going to interfere with her ability to do her job. The City of Toronto brought a motion for summary judgment. This is where they want a judge to decide the issues in a more quick manner than going all the way to trial, because they're saying the judge can make a decision based on the evidence that they're providing. So they brought this action and they said that the judge should dismiss the action because it wasn't brought within the 10-day notice period as required under section 42 sub 6 of the City of Toronto Act, which is the same as the Municipal Act also provides for a 10-day notice period. The court did not dismiss her action. Doesn't mean that she's going to necessarily succeed in her underlying action and that the city was negligent, but it means that she can at least proceed with her lawsuit. The judge looked at the following factors. First of all, the plaintiff had a very demanding job that required her to work beyond the 9 to 5 hours, beyond Monday to Friday. She was focused on doing her job, and this was part of the reason why she was delayed in giving notice, and the court considered this factor. It wasn't just this factor though, all of these factors taken together were what made it reasonable. The other issues that she brought up was that only after attending physiotherapy for 2 months without improvement and continuing to struggle with being able to do her job did she realize maybe she wanted to bring a lawsuit. She maybe wasn't thinking that initially, but she became at this point more concerned that she was going to have serious effects because of this accident. Another factor was that her recovery was more difficult and lengthier than she expected, and she did not initially realize that her injuries were this severe and that they would have this significant effect on her and her lifestyle. She also did not know about the notice requirement, so that alone won't be sufficient, but taken in the context, that was something the judge looked at. Also, the delay was only 3 months, which the court considered not to be all that lengthy. Considering that the limitation period to sue for this action normally without this shorter notice period would be 2 years. In this case, the judge determined that the 3 months was not a significant length of time and it wasn't all that serious, that delay. The court decided that none of these factors by themselves would have been a sufficient excuse, but when you compile them all together and the context of this action, where she had all of these different factors, her work, she didn't know about the notice period requirement, it wasn't all that long of a delay, she was preoccupied with her injuries and getting better, the court did decide to give her that leniency and said that it didn't necessarily any of these one factors amount to a reasonable excuse, but the combination created a sufficient excuse to justify the plaintiff's delay. This conclusion was reached in spite of the fact that the plaintiff did have the capacity to give the notice within the 10 days. So sometimes it would be more so if she was in a coma or she was completely incapacitated. But in this case, the court said that there is more leniency depending on all of the factors. The doctor was the one who had also told her within 9 days that she should file a claim. The issue was that the plaintiff did not think that she was going to necessarily want to bring a claim. She didn't realize how significantly injured she was until about 2 to 3 months after her injury. It's very important here, the court also emphasized that a plaintiff or the plaintiff here should not be disadvantaged because rather than immediately thinking of a lawsuit, she preferred to see if her injuries would heal. The court also took into account the plaintiff's explanation that her job was occupying much of her time. Maybe a judge can have some sympathy with a job that requires a lot of their time and attention, and that they would not be fully focused on, oh, I should be suing. They would be trying to do their job. So that was the case here where the plaintiff had that situation. The other very important factor that is not necessarily within the plaintiff's control, but in this case, the court held that there was no or very little prejudice to the municipality caused by the 3 months of delay to the notice. The court supported the proposition that when there is no prejudice due to the delay, a modest excuse may even be sufficient. So do not think because you've missed the 10-day limitation period that's listed in the Municipal Act and the City of Toronto Act that you are fully out of luck. There are ways that you can craft an argument around the 10-day notice period. Always depends on the circumstances, and you should always speak with a lawyer about your specific circumstances. I'm always available for a chat about this type of thing. You can give my office a call and set up an appointment. Please have a look at my other videos too. I have more information about lawsuits and some legal information.